Please let me know when I may start the lecture. And confirm that you can hear me.
We can hear you well.
Thank you.
I suppose you can start, and our students are going to join the meeting.
Okay, if we want to wait 2 or 3 minutes more, I wait. If you think there are more students going to connect,
I'll check if you don't mind a couple of minutes, and then I'll tell you again.
Yes, of course, as usual. Okay. It is a pleasure anyway to be in connection again with ASU University. I don't think we had the chance to meet 2 years ago, or maybe, yes.
Well, I think we can get started.
Okay, thank you very much.
Thank you.
So thank you for the Astrakhan State invitation to give a lecture to the students of international law course. It is a great pleasure, a privilege to have this chance. Since 2 years ago and more, our university, Astrakhan State University, and Unimol, University of Molise, a region in the center of Italy, we take this decision to sign an Erasmus Plus agreement. And as you probably know, following such kind of agreements, we may exchange students and professors. And we had actually 2 years ago the chance to have students from ASU University in Italy at Unimol, and exactly 2 years ago, in May 2019, I had the great pleasure to come in Astrakhan and give lecture to some of your colleagues. Unfortunately, this year is still difficult to come, to travel, but I'm sure that we will have soon again the chance to meet in person. And I invite all the students of the University of Astrakhan to profit as soon as possible as the program. I think 2 years ago, 5 students of ASU came in Italy, spent various months, 6-9 months, and I think their experience was quite successful. They had good results in the exams, at least. So this is just to explain why I'm here in online, fortunately, and I think that today I may give you only a quick introduction to the Italian legal system. I don't know what is your knowledge about Italy and Italian legal history. So as it is common in such situations, I will give you a very basic introduction, but I will be very happy if you may make questions or observation or ask anything you like to know. Okay, so do not hesitate to interrupt me. And in case you are anyway interested in some of the aspects I will explain, please send me questions by chat or directly with intervention with a speech. Okay, so I will try to give you a wide panorama, partly historical, partly connected to the actual situation, to the Italian legal system and judiciary system. I will try to share my screen and to let you follow the lecture with the help of some slides. Let's try to see if my system works. Okay, can you see my screen? Anybody wants to answer?
Yes.
Okay, this is fantastic. Okay, introduction to the Italian legal system. Of course, you may imagine that the Italian legal system is very old and connected to the Roman experience. But if you look at the history of the Italian nation, actually you will realize that the country as unified nation in the modern time is quite recent. It's a young country because it was unified only in 1861, so not much more than 1 century and a half. But of course, this is not the sole thing to analyze, because the legal roots of our system are much longer and much deep in the history. So, of course, we have to give a short representation of the basic moment of the Italian legal and cultural history to understand the actuality, the actual times. Part of this experience, I may imagine, is already known and even partly common to the Russian system, the very old roots, but of course, part of it may be different and has to be explained. So let's start with this first resume of the basic parts of this history. It is the Italian legal system, the Italian country, a perfected evolution of Roman law. This is a question that maybe make at the beginning of our presentation, because everybody of you, I suppose, has some knowledge of the Roman history, the old empire history. And so you may imagine that Italian legal system is just an evolution of Roman law. Actually, this is only part of the reality, because through the centuries, the Italian culture, not only the legal culture, but especially the legal culture, had a combination of different contribution, especially in the Middle Age period, in the period that is traditionally called Ius Commune period, the period in which in the center of Europe, especially in Italy, France, Germany, Spain, and also part of the East countries of Europe, there was a sort of common law, not in the sense or in the English sense of the term, but this was an evolution of the Roman law with the integration of local and specific tradition of different countries. Within this period, and afterwards, in Italy, we had other heavy influences. And of course, we have to take in consideration the canon law, so the law of the Catholic Church, of course, and then later on customary laws, specifically and particularly in the Middle Age, in particular for the commercial law and law of property. And then later on, we have a too strong contribution of, in the centuries, let's say, since the 18th century, of the ideology of the French Revolution, and not less important, the German legal scholarship around the 19th century. So in this phrase of my colleague Miranda, you may find a sort of resume of the basic elements of the cultural Italian tradition and legal Italian tradition and different connection with other European traditions. In one single image, you may see here the four basic elements. You have here a very famous mosaic in Ravenna. Do you notice this famous one? Anybody knows this man in the center? It's a difficult question. It is the Emperor Justiniano, no? Justinianus, in the 6th century. So this is the symbol of the Roman time, the end of the Roman time. And then we will see a bit more about it. The second, this is a famous church in Ravenna. If you have the chance to come in Italy, not far from Venice, you have to visit this famous church and mosaic. Second step, very important, is the studies in the universities, at the beginning in Bologna and then in various universities in Italy, but not only in Italy, of the Roman texts, books, digesta, and all the evolution about interpretation, integration, and harmonization and modernization of the Roman legal tradition. This is a work that goes more or less since the 11th century to the 17th century in Italy. Then we have the two other European traditions that had a very big importance, especially in the 18th and 19th century. This is, you have another famous painting. It's not an Italian one, it's a French one. This is the famous Marianne, the symbol of the French freedom, the freedom, the principle of freedom of the revolutionary movement at the end of the 18th century and at the beginning of the 19th century in France. And as you will see, the French model, the French codification, it was a very important model for the Italian codification and Italian legislation, especially in the 18th century. But at the end of the 19th century, we had another influence, the great influence of Germany, as Germany was unified in the second part of the 19th century. And immediately the German work of scientific work in universities, professor especially of the two schools, this historical school and the Pandect school in Germany, were included in the work that has produced the new code, the BGB, Bürgerliches Gesetzbuch, who was introduced in at the end of the century, in the year 19. This influence was very important, especially for, let's say, the legal literature, doctrine in the universities, made an important influence also on the most recent codification in Italy, the actual one, that one that is still enforced, that is the code, the civil code of 1942. Okay, so we have to look at these four influences more closely and to understand what is still in the Italian legal tradition and legislation of these various traditions. Let's start with the Roman one. Usually, we think to the Roman law system through the image of this man. We have already quoted the Emperor Justiniano, because he was the great emperor of the Corpus Iuris Civilis, as you certainly know. So this collection, this huge collection of the Roman sources, legal sources, that was made by the Emperor Justiniano with the assistance of his most important jurist. It was at the time the professor, diciamo, Tribonianus. But this was actually the very last product of the Roman culture. And if we look at the Roman history, and the Roman experience was much more composed with different periods and different sources that, as you know, as jurists, are very important to understand the way, the evolution, the roles of different institutions in a certain system. We may quickly, very quickly, describe the Roman law period, history for the law system, distinguishing three periods, especially for public law point. This is very clear, very, we have a first period of more or less 2 centuries and a half of the monarchy time. We are between the 8th and the 6th centuries before Christ. And then we have the Republican period that ends with Julio Caesar, of course, and so the 1st century before Christ. And then we have the imperial period, the period in which Rome was a great and growing empire that is starting in the first period, the 1st century before Christ, and actually in the western part of the country, the empire, in Rome, in the Italy, ends more or less in the 5th centuries, when there were barbaric invasions. Of course, afterwards, there was a very long period in the east part of the empire, in Constantinople, where the Roman Empire kept its force, its existence up to the end of the 15th centuries. So more or less 1,000 years more. So you can imagine how long is this history of the Roman law system, how it's complicated inside. Also from the civil law point, there are differences. We had a very old period that ends more or less in the 4th century, but we had already in the 6th century the first written laws, the so-called 12 tables, the law written on the stone and published in the forum that gave the feeling to have a different system, not anymore a system based on mores and leges, but especially on the lex scripta, so in written laws. But we had a long period. This is important to understand how was rich the Roman experience. This period, this so-called pre-classic period, so from the 4th century to the 1st century before Christ, in which there was a great importance of the judges, or the praetor. So we have to think to the Roman time also of a period in which the production of the law, rules, legal rules, were partly due to the activity of judges, the praetor, urban praetor and the praetor. Of course, afterwards, we had the classic period in which there was an emperor, and in this time, the role of legislation was acquired and more concentrated in the hands of the emperor. So we have the constitution, leges, and other sources. And at the end, we have the so-called post-classic period, in which we have seen, especially with Justiniano in the 6th centuries, we had the great work to reorganize the whole tradition of Roman history in a system, or at least this attempt to reorganize the sources of more or less 1,000 years. You imagine how long it was already, that experience, in a system more or less well organized, not without conflicts within different sources. Legal sources, different sources in different periods. So we don't have to think to the Roman time to a system in which the law was written or the was codified, only because at the end there was the Emperor Justiniano who codified the Roman law. Because we had, for sure, at the beginning, especially at the beginning of 4th centuries, the archaic period and pre-classical period, a large importance of mores. Mores are customs, okay? The use of the people, the repeated conduct of people that become a source of the law, a basis for the decision of the judge. But more and more, since I said the 12 tables, so-called 12 tables, we had written leges, written laws, written statutes, and of course, more and more production of the judges. So we would say decision, jurisprudence, and also in the classic period, what is perhaps the most impressive production of the Roman time, the huge work of the, we should say now, the lawyers or the professor of law or the jurists. So a great number of opinions, responsa, written works concerning the explanation of specific concepts, specific cases. And this was a production that occupied 2-3 centuries at least, and that was afterwards included in the Corpus Juris Civilis of Giustiniano. In the last period, of course, we have again leges of the empire, jura, production of the opinion of the experts, and customs. So what we have at the end of this long history, it was already a more than 1,000-old history. We have the inheritance of Roman law that crossed the centuries, and that was afterwards, after the year 1000 especially, analyzed, studied again in the university. What are the main elements of this long tradition, cultural Roman tradition? First of all, I would say a specific idea of what is the law. At the difference of other cultures, for instance, the Islamic culture or other legal system, the basic idea in the Roman time was that the law is different, something different, specific field of the culture, different from politics, religions, and ethics. Is something that is made in a specific system with the intervention of judges, leges, specific institutions, and this is a specific part of, let's say, the cultural patrimony of a certain culture, a certain people. This is something that is more or less an invention of the Roman cultural experience. Then, second point is the codification of Giustiniano. As I said, this is the moment, 6th century after Christ, in Constantinople, the actual Istanbul city, in which at the time there was the center of the empire. So something, an area very far from Rome, very far from Rome. At that time, Rome was already conquered by various barbarian people, and only part of Italy was under the direct control of the empire. And what kind of codification Giustiniano could organize at that time? Certainly not a modern civil code like the Italian, the German, the French, or the Russian civil code. The Corpus Juris Civilis, as you see here, it was a collection of 4 basic different parts. The first one was the so-called institutions of Giustiniano, a sort of manual, a very, let's say, quite simple presentation of the basic elements of the law in order to explain it to the students, let's say, to the people interested in it. Then we had the second part, very important, the pandicta, the collection of 50 books. At the time they were, of course, papyrus books, with parts of and a collection of the opinion of the great jurists of the classic period, so more or less 2-3 centuries. So this is maybe the heart of the Roman tradition that was afterwards taken again in consideration during the Middle Age. Then we had a codex, but codex at that time used to mean a collection. A collection of what? A collection of the constitution. Constitutions were at the time the laws, the statutes of the emperors, since Adrian to Justiniano. So the codex, this is just a part of this Justiniano Corpus Juris Civilis, was just an organized, structured collection of the laws of the emperor constitutions. And the fourth element was the novelle, so another collection, the collection of the most recent constitutions. So as you see, what was, if in a sort of mean to transpose through the centuries this huge Roman law culture, was unified, organized, systematized in the Corpus Juris Civilis. And within this Corpus Juris Civilis, within this opinion, responsa, we find a large number of legal concepts that still today are part of our legal tradition, like, for instance, property right. The idea of property may be declined in different ways. For instance, it's not the same, the property in English, in the English legal system, and in the French, German, and Italian legal system. The systems that have their roots in the Roman law, like of course Italy, France, Germany, and other countries that have were influenced by the same experience, are still based on various concepts in family law, in property law, in obligations and contracts, still based on these Roman legal concepts. Okay, this was the first big part. But what happened? What happened is that in the centuries between the 6th and the 11th centuries, in Europe, and especially in Italy, we had a sense of strong central state. We didn't have any more an empire. There was not the emperor of the East Empire enforced there, only in a few towns like Ravenna, the town of the mosaic I've already shown, and we had influences of various, let's say, barbaric populations with proper traditions, proper ways of life, and so on. And this experience was so long that, in practice, the Roman law was for some centuries nearly abandoned, nearly not even known anymore. Even the Corpus Juris Civilis, at the end of the first, at the end of the 9th of the 10th century, was unknown in Italy. What was the important thing is that around the 1000 year, this book, this collection of books, came back in Italy through the contacts with commercial contacts from the maritime towns like Venice, Naples, Genoa, Amalfi. And these books, these Roman old works, came back in Italy. And what happened? That In Bologna, especially in this place, we had a new form of sources of law. We had the studies of the old works of the Roman time. But what happened in between? In between, we had a situation in which the sources of law were very various, were very different. We had, for instance, for the merchant, for the, let's say, economic law, the usages of the merchants. For the jus publicum, we had states, we had constitutions or other sources of the local barons or kings. We had the great importance of the Justa Canonicum, the law of the church, that was partly based on the Roman tradition, but had, of course, different principles, different basic values. And of course, jus commune and customs. So, of course, in this period up to the 12th centuries, we had a different customs in different areas and different sources connected with the same basis coming from the Roman time. So what happened afterwards? Have you any questions? Is everything clear there? Please give me an answer so I'm sure that you are following me.
Yes, yes.
Okay, thank you. It is clear. I can go on. So let me show you this other. What we had at the beginning of the new era, of the second part of the medieval period, in Bologna since the year 1088, we had the formation of the universities, what afterwards we called the university. Especially in Bologna, this man called Irnerio used to start to give lectures on what? Of course, on the Corpus Juris Civilis, on this book or series of books coming from the old Roman times. And of course, the first work was that one of the glossatori. The glossa means a very short explanation of the meaning of a text. And the first work was just to explain something that was more or less not anymore known and was part of a very old tradition, not already, I would say, in connection with the actual time. So this work of the university, of the great professors of Bologna and other universities in the north of Italy, but from there everywhere in Europe. You may imagine that, for instance, even a university quite far, like Oxford, were founded by professors coming from Bologna, or and the same happened in other universities in the center north of Italy, and then in France and in Germany as well. So it was really a sort of spreading this model around the world of the European countries at that time. And this proceeding, this idea to take the Corpus Juris Civilis, to take all the Roman sources, to explain it, to try to comment it and to update it And to give a better systematic of these sources was the long work of the universities for 2-3 centuries. And this was a common experience in the Central Europe, and from Spain to Poland, from France, part of England to Germany, and some part of the eastern country as well. Okay, but this from this point, of course, we had different experience in the different European countries. We had countries like France and England that became quite quickly, and Spain as well, a bit later on, became a nation with a king and who controlled the entire territory, who could help the evolution of the legal system, impose rules and establish courts. And this, in this country, especially in France and England, we had a national evolution since the 15th century, perhaps in England even before. On the contrary, there are countries like Germany and Italy that for more than 2-3 centuries were still divided in many little little areas with kings or barons or bishops divided in different political entities. And so they they only in the 19th centuries became a unified nations. And it's obvious that, of course, in these countries like Italy, the role in Germany, of course, the role of the so-called usus modernus pandectarum, so modern use of the old Roman opinions, pandecte, appunto, were the opinions, was lasting for centuries later as this first experience in the university in the 11th, 12th centuries. Okay, but what happened? That even in other countries we had an evolution based on new ideas, new ideologies. Since the 17th centuries, we had the so-called jus naturalismus, the ideas of a law based on the nature, of the idea that people, the human beings are equal, and there are some natural rules connected to any person without distinctions. And of course, in the 18th centuries, these ideas evolved in the ideas of the rationalisms and the Enlightenment movement, especially in France and the north of Europe. And there was, of course, a reaction against this system, like the, let's say, usus modernus pandectarum, that was still considered uncertain, contradictory, and arbitrary, partly arbitrary, because, for instance, was based on the idea that the people had different rules depending on the class or groups of which every person was taking part. And of course, in these centuries, we had different rules for the priests, for the aristocracy, for the common people. And this, against this idea, we had the French influence that, of course, became also the basis of the French revolutionary constituent. And so the idea was to build a new ways, new values, and to set up a legal system based on these new values, and especially which ones, especially the idea of equality, freedom, and how to say, a friendship between people. And of course, we all know that this French Revolution had a very end of thanks to this emperor that we have the new codes. The code in the 1799, Napoleon got the power, and one of his main goal was that one to give to the France a new civil code, a written civil code. Even during the revolutionary system period, there were projects to approve a civil code that could be the same for everybody, for everywhere, for people of the aristocracy or any class, for the priests, for women and men. But during the revolutionary period, it was impossible to approve the code. On the contrary, in 1884, thanks to the Napoleon influence, it was, we must admit it, a code was approved, and this code is not only a law or a consolidation or a statement of the law of the, let's say, ancien regime, the old regime, but it was a code integrating a new vision, a complete, ultimately body of law based on new values. So it was not only a new source, but it was also a new system of values and rules. Both we had not only the French civil code, but also the codes of civil procedure, a new commercial code, so specific code for the economic context, and a code of criminal code and civil code of criminal procedure. So this was the great period of codification, modern codification. This is something different from the old Roman codification, because it's a single law giving a systematic regulation of various part of the legal system: private law, criminal law, civil procedure, commercial law, criminal procedure. What was the influence of this in Italy? Why I was so attentive to this aspect? Because this was actually extremely important even for Italy, that at the time was invaded by Napoleon, who conquered more or less, not all, but large part of Italy. He conquered the north part. It was in Rome, of course. It conquered Naples and the kingdom of the south, of the two Sicilies, called. But of course, as we all know, the experience of Napoleon finished in the 1815. So we had the restoration regimes in all Europe. But what happened the legal rules, the systems of the different nations came back to the preceding situation? No, absolutely no. And even in Italy, the situation was changed forever. Even in the kingdom, and you see here the names, the Regno delle Due Sicilie, was the biggest kingdom in Italy. They came from, let's say, Rome. Rome was under the Pope kingdom, from the center of Italy up to the south of Sicily and the south of. And then we had immediately after the Waterloo battle in the 1819 a new code, and this code was based on the Code Napoleon. And the same in Parma. This is in the Duchy in the north. We had in 1921 different codes: civil law, criminal law, and the same important kingdom on the north, Kingdom of Sardinia, but Piemonte, Sardinia. And here we have in the same, a little bit later on, civil codes. So this was the situation of Italy before the unification. Unification happened in 1861, and 10 years later, in 1870, even Rome was conquered, and the Pope was expulsed, is the territory of the Pope, let's say, kingdom, became part of the Italian kingdom. So we had this unification. We had this man here that probably you know. His name was the Generale Garibaldi General, who was the great hero of the unification of Italy. Okay, when we had this unification, what we had? We had a new constitution on a monarchy. And of course, we had a different approach. This different approach, the idea was to have a codified system, not anymore a complicated system based on the very old rules or the opinion of the Roman time, but as in France, a civil code, a commercial code, and different codes. So we had the first Italian civil code, 1865, and in practice, we have to admit that it was imitating for large part the French model. This is why I put the image of the Marianne, the French symbol, like third root of the Italian actual legal system. Okay. What happened afterwards? Afterwards, we had in the middle between the 19th and the 20th century, the influence of Germany. Of course, Germany had the same experience of Italy, so arrived very late to the unification. Unification of Germany was more or less in the 1870, same period of Italy. But what was very important in the 19th century in Germany, that the importance of, again, university, the role of scientific study of law, the idea that law and legal rules are a specific subject of studies of a scientific work in order to give a systematic system to a new nation. In this period, in Germany, we had I will synthesize two different schools: the historical school of Friedrich von Savigny, and then afterwards the Pandectist school of Buchter and Winscheid. The first school had the idea that the law is a product of the Volkgeist. So it's sort of a product of the people. Is sort of a custom and a romantic idea that the people, every people, to contribute slowly year after year to consolidate a system of rules. And so for this reason, the first part of the 19th century could not get a code. The idea was to wait because following the von Savigny idea, it was too early for Germany to have a code. But afterwards, they had, and because of this, they had to take anyway the ideas and the ways to let's say build rules and to build a systematic legal system. And of course, in Germany, like in Italy, at the time, there were not codification, only in some part of it, but the great heart of the studies in the university were still the Roman opinions, the Roman sources, of course, especially the Pandecte, so the opinion of all the Roman jurists, judges, lawyers. But was the great effort of the German Pandectists? It was to interpret, to make, evaluate, to systematize, to specify every concept, every idea was coming from the old Roman time, and to build a system. And build a system at the end was concretized in the new BGB, the Bürgerliches Gesetzbuch, who was entered into force in the year 1919, at the beginning of the new centuries. Okay? So another big country, very important country, with which, as you may imagine, especially at the beginning of the 20th century, Italy had a very strong relationship, not only cultural, but after also political relationship, that gave a different influence to the Italian legal system. In one side, in the 19th centuries, the idea of the values and the model of the civil code of France, and in the other side, the idea of a systematic scientific system of rules based on the Roman concept as in the Corpus Juris Civilis, as elaborated by the glossatori and commentatori during the Middle Age, but already reorganized in a new form, in a new code, the Bürgerliches Gesetzbuch, so the German code, but also, finally, also a new Italian civil code. This was the great innovation of the Italian legal system in the 20th century, because if we may say that the first code, the first Italian civil code, 1865, was more or less a copy of the French civil code, if we may admit that the German influence was extremely important for the Italian doctrine, especially first years of the 20th century, we may and we have to underline that the new Italian Civil Code of 1942 is something new, is different, maybe a merger of the two experiences. This code has a new structure organization. We have not more the 3 books of the French Civil Code, not the 4 books of the 5 books of the German Code. We have 6 books in which we find part of the Roman French tradition, personal and family law, but something that is new, property law. This is still part of the old tradition, but we have as well something new, a book on labor and a book of on obligation, law of obligation. Obligations come, of course, from the German model, German book code, in which there was, of course, a part dedicated to the contracts, to the obligations coming from a contract, coming from other sources. But what is important that in the 5th book, labor law, the Italian Civil Code merged what was still autonomous, distinguished, both in France and in Germany, that was all the economic and commercial part. So Italy, together with Switzerland, was more or less the first country to have a new idea of the society in the 20th century, in which there is no more distinction between civil and commercial relationships. Of course, there are specific contracts for commercial relations, banking, insurance, transport, industry, and so on. But there is not the idea of a society distinguished in 2 parts, the civil citizens, and the merchants. With this code, this was part also of the fascist period, fascist idea of the society. There is a unique society, and then for that society, we decided to set up a new book, a new code with a unified regulation of private law. This code was the son of the, let's say, fascist ideology. Well, this is a very difficult question. A lot of great professors and intellectuals have studied this aspect, and this is only part of the truth. Certainly, there were some institutions, some rules, some specific organization that were part of the fascist idea of society, but this part were quite quickly abolished after the war, the Second World War, especially through the activity of the Constitutional Court. But at heart, the biggest part of this Italian Civil Code was based, as you may read here, and I quote, according to the liberal ideology, Italian legal authors kept clear of political, sociological, and economic contamination, protecting the purity of legal method and freedom of thought. As you remember, I quote at the origin that one of the heritage of the inheritance of the Roman time was the idea to have a legal system as something distinguished from the political, moral, and religious view of the world, of the society. And so this was part of the liberal ideology, was at the base of the new Italian civil code, at least large part of it. This is why, after the Second World War, this code was more or less kept in force, with some exceptions, of course. Sorry. What happened during the Second World War, as you perfectly know, the war was extremely difficult period for Italy, like in Russia, of course. Italy was in large part destroyed, physically destroyed. And in the 1943, the so-called Republic of Salò, the last bit of the fascist system, was conquered, was abolished. And in the 1946, we had a referendum, after which the Italian people decided to have a republic and not anymore a monarchy. So we had a public law evolution, very important, and we had for the first time a republic, Italian republic, and since 1946 this is the system. But not only that, from the 1st January 1948, we had a new constitution, a new written constitution that gives a system of political powers, completely new. Let's have a look. Are you there? Are you still in force? You have any questions? Do you have any questions? Okay, maybe later. I will leave you a bit of time to think and to make questions. Okay, let's have a look now at the actual Italian law system, legal system, and to this sort of pyramid of sources. What are the sources of law in Italy at this moment, in the actuality, actually? First, we have at the top, of course, the Constitution and the constitutional laws, of course. And but as you will see in the next slides, since the 50s, Italy was one of the founders of the European communities, and then it took part in the European treaties, and then, of course, we had to merge the constitutional rules and values with the European treaties values. So at the top, we have Constitution and European Union law. Then we have the so-called, sorry, there is a question maybe?
Ребят, пожалуйста, задавайте вопросы профессору.
Yes, sorry, okay, please.
Если что-то интересно или что-то непонятно, пожалуйста.
Hello.
Hello.
Is there a clear definition of national security and public interest?
Well, this is much later principle. No, in the Constitution, we don't have a definition of course, we have reference to this concept that is very important, of course, in the actual times, but the interpretation of what is security and what is the basic interest of the nation is part of the interpretation given that is up to the Constitutional Court. And this is, of course, one of the points that now are even within the European Union treaties and sources in a very important discussion because, of course, the foreign politics of the countries in the European Union are actually partly, at least for commercial aspects, harmonized by the European treaties and partly competence of the European institutions. So it is true that this is a very delicate aspect, but we don't have a so specific definition in the Constitution. Thank you for your question. Very important now. Okay. Any other questions?
Yes.
Yes, thank you.
Hello.
Yeah.
Is there a clear definition of national security and public interest?
This is the question I've already.
Yes.
Okay. Any other question? No.
No.
Okay, not for the moment. Okay, thank you. So what are the other levels of sources? As you can imagine, we have the primary sources, that means ordinary law at national level and regional level, because since the 1970s, we are, of course, Italy is not a federal, it's not a federation like Russia, but it is a unified country, but as regions, 20 regions. And since the 70s, the Constitution has attributed to the regions the power to regulate some aspect of life, as for instance, part of health or environment or commerce rules are based on regional laws. Of course, then we have the secondary sources, what we call regulations, that may be at the government, national government level, or even regional level government. And of course, at the very end, we have uses and customs. I must say that these sources, that was very important before the codifications, in Italy actually is very, very marginalized. Is mainly relevant only if in the contract in other source is make reference to the parties make reference to the uses. If we don't have such kind of clauses, mostly these sources is irrelevant. So we see how through the centuries we had a complete changement of say systematic in the Middle Age up to the codification, the uses, even the local ones were the base of the law integrated with other principles. Now they are a marginal rules for a situation in which they are called to integrate the law. Sorry, a bit again on this slide. the true basic principle, I think, very well known, hierarchical principle, chronological principles, and competent principles. In order to integrate these sources of different level, we have to integrate the three principles. So sometimes even the chronological principle is relevant at the same grade sources. Competent principles depend on the jurisdiction, the role of a source in a certain subject. Okay, this is quite clear, imagine. Okay, before to come back to the Constitution, to some very basic aspect of the Constitution, let me quickly present the stages of European integration. As you certainly know, the Treaty of Rome, the basis was in 1957. As you see, we were at the level of European Economic Community. So it was not a political, let's say, 360 grades approach. It was a sort of specific approach, community of European economic aspects. But since the 90s, with the Treaty of Maastricht, the perspective changed. We had the European Union, and then since then, with the Treaty of Amsterdam, Nice, and then with the last one, Treaty of Lisbon, 2007, we have a deep modification of this approach with a more and more integrated system. Now we have, of course, the two basic treaties, the Treaty of the European Union and the Treaty of the Function of the European Union, and of course the European Charter of Human Rights, that is the so-called Nice Chart, that of course is there are many references to this chart in the treaty. So this is already part of, let's say, European Constitution. Then we have the Treaty of the European Community for atomic energy. European values, I don't think we have to deep this aspect. I suppose you know, human dignity, freedom, democracy, equality, rule of law, and so on. And of course, the European rights of the European Union that are now part of our legal system, because these fundamental rights have a direct application in all the European countries and in Italy as well. Okay, don't think, one element that is certainly important, even in the relation with Russia, is the common the two countries are part of the European Convention for the Human Rights and Fundamental Freedoms, like many, more than 40, I think 43 countries in Europe, not in the European Union, of course, in Europe in sense of geographical sense. And so there is a sort of circulation of principles through this convention and through the interpretation of this convention given by the Court of Strasbourg, of course, with this European Court of Human Rights. We have in Italy, like all countries having signed this convention, a common core of human rights principles. And between them, for instance, there is the principle of quite, I would say, the limited time in which the courts have to decide. For instance, this was a difficult point for Italy, in which we had and still we have a great number of litigations, and so we have difficulties in having decision in short time. So through this convention, Italy was in many cases sanctioned for this long time of the civil and also criminal proceedings. This, let's say, influence is relevant. I would say that both the influence of the European Union and of the European Convention are forces that are, I would say, slowly, but changing the, let's say, substantial constitution, the effective constitution, the Italian country and legal system. Of course. Well, very quickly, because these are already part of the Italian legal system, the two or three slides about sources of the European Union law. As you probably know, the European Union law is not only the treaties, but there are sources of the secondary level in which we distinguish regulation directives fundamentally. As you probably know, the regulations are binding legislative acts, and they have to be respected by all the people, all the countries and citizens of the European Union. So they have a direct effect in Italy, not only to the Italian state or Italian public institution, but also to any people, any company, any legal subject. So these are already a large part of the Italian even private law, not only private, but even in private law. On the contrary, the directives, the European directives, are legislative acts that sets out some only goals on specific direction, I would say, of the European legal system, and they have, in theory, in principle, not a direct effect on the individual people. So, in principle, the directive is directed to the countries, to the states. They give principle on which the single countries have to regulate internally their country. But the evolution of the European Union is in the sense that if the directives are specific, sufficiently specific, they may have even the pure directive an effect on the citizens, on the relationships between private people. So this distinction that was at the beginning of the European Union system, something, let's say, basic, is actually less important. We have some directives that give, let's say, rights to the citizens in Europe. Then we have, of course, decision recommendations, decision having a binding force only a specific subject, recommendations that are not binding, but still very relevant in the evolution of national law in all European countries and in Italy. Let me say something about, let's say, the psychological relationship between Italy, Italians, and European Union. Beyond more or less the let's say the formal sources. Certainly, Italy was one of the countries founder of the European communities at the beginning, and then of the European Union. So was one of the countries very in favor of the European Union. And this was part of the, we must be even proud of it, of the intellectual evolution in the thought, legal thought in Italy. The idea of having a international level of interaction beyond the states is quite antique in Italy. We had even in 19th centuries great intellectuals like Mazzini, and then in the end of 19th centuries, a great professor of international law like Pasquale Stanislao Mancini. And then, of course, in the 20th centuries, people and intellectuals that gave a great support to the practical constitution of the European Union, especially with the famous Manifesto of Ventotene during the Second World War, or before the Second World War. And so we must say that in principle, the intellectuals in Italy had always a position of openness in the sense of reaching a good relationship, even a level of political integration beyond the nations. This phenomenon changed partly in the end of the 20th centuries because of certain rules, especially economic rules of the European Union, that were quite heavy for Italy, especially because of its high debt, state debt. And this is why part of the political opinion, quite relevant, in some years was against the growing of political power at the European Union. At the moment, I would say that this phenomenon is more, I wouldn't say over, but is decreasing. So we are going again in a situation in which we have a good feeling with the European Union. Even then, sometimes in Italy we don't have the same approach of France or Germany. Okay, this was a little bit out of records. And then opinions, okay, we don't. Let me give you some information about the legal systems, Italian system, before closing our lecture. Of course, separation powers. We are a republic with respecting the principle of separations. We have then parliament, government, and judiciary distinguished, highly, rigidly distinguished, especially if we look at the judiciary. In our system, we have, I would say, the most rigid protection of the impartiality and the autonomy of the judiciary. Probably the most rigid distinction we find in Europe, if maybe in the world. This is, of course, a reaction to the historical experience of fascism, in which even not only the administration, but all the judiciary members were submitted to the power of the fascist government. So the idea in the constitution was to protect the judiciary from the political influence. This perhaps may have opened the floor to an opposite criticism. Then sometimes the judges or more the public ministers may be even so powerful to have a political influences. We had various cases of public ministers that became politicians and were protagonists of cases against politicians. So we have a strong separation of powers with this underlying aspect. Okay. Oops, it doesn't go on. Okay, back to the basic. Okay, democratic republic founded on labor. Okay, this is sovereignty to the people. Article 2, the inviolable rights, not only to people, individuals, but also social groups. And of course, fundamental duties in terms of political, economics, and social solidarity. Article 3, again, basic principle of equality without any distinction, language, religion, political opinion, personal and social conditions, sex and race. This is at the moment quite important, especially for a distinction in terms of sex and race. And of course, we had special rules in terms of religion because, of course, of the Catholic majority of the Italian people. But at the moment, this is not a problem. But there is a strong movement in favor of a sex equality, gender equality, and race equality. Then what we may say in general, in general terms, we have a civil code in which we have the blueprint of the different, let's say, traditions, legal tradition. I quote during all my presentation. We have, for instance, some Roman rules in some articles, for instance, about interpretation of contracts. We may have some notions coming from the canon law, so the law of the church, the Catholic Church, for instance, in the marriage. Some medieval rules, for instance, the idea of legal person, a company or a foundation that be a legal person, something invented in Middle Age. Some natural law rules, Illuministic, Enlightenment, and French Revolution ideology principles, and from the commercial codes of the last world. So this is why I spent so much time to give you a vision of our long history, because of course this is not something that is just in the past. It is still, let's say, in our blood, in our DNA, but is still also in our basic rules of the civil code and partly of the constitutions. in the Constitution, we find, for instance, some basic principles, and you see here that they are all in Latin. There is, do you study Latin in Russia, or is unusual to do that? Let me make a question for you.
Yes, yes, we study.
Okay. Okay, so as you see, this is still part of the common cultural tradition. And as you see here, the principles of basic criminal rules are translated here from Latin formulas. So nullo crimine nulla pena sine legge, and so on. Just to say that this is an article of the Constitution based on very old Roman or Middle Age tradition. I don't want to discuss the single principle, but this is the idea that we want to. The principle of legality, what does it mean? The principle that the rule of law, there are no sources of the legal system that are not admitted by the law. So it's not an open system. What are the sources of law are only what is written in the Constitution in the ordinary laws. We may not have different sources that are not already recognized as such in these sources. And then, especially for criminal law, strict interpretation, no reactivity for criminal law. Another very delicate point, public administration. If I would reveal some fable point of Italian system, maybe public administration. We had in the 90s a general law on administrative procedure and principles of public administration. And of course, the general principles are efficiency and impartiality. But this is not always easy to apply. Other principles very important are the criteria we find here in section 1 of this law, the criteria of economy of action, effectiveness, impartiality, publicity, and transparency. And this approach was quite revolutionary, I would say, in the public administration in Italy. And this law is the basic of all relationship, even litigations against the public administration in Italy. At the moment, the idea of transparency is extremely wide. So we have a very limited situation in which the public administration can keep the secretness, secret information only if there are very special needs based on the public security or national interests. Then we may go on quite quickly. A quick look at the Italian judicial system. We have a distinction more or less in these three big fields, like civil law, criminal law, administrative law. But in practice, in civil law and in criminal law, we have the same structure. So we have 3 levels of courts. First, tribunal, court of appeal, court of cassation. What is the distinction? The distinction is that the 3rd level, so the highest level, court of cassation is a single court sitting in Rome. has the role to look at the legality of the proceedings and of the decision. Is not giving a decision, I would say, on the facts, on the conduct of the parties. It's just judging if the decision of the tribunal or the Court of Appeal are responding to their procedural and substantial rules of the law. So this is a limited control at the highest level. On the contrary, for administrative law, we have only two levels, the tribunal at the regional level, 20 regions, and a centralized court for the second level called State Council, but in practice is a court. Okay, and only in case of the doubt if a case is civil or administrative, is the Court of Cassation that has to be called to give an answer. The Constitutional Court, of course, we have in Italy, the system, the so-called, let's say, Austrian model, Kelsen model, in which we have a constitutional court distinguished to the other courts. And this court has the power to take decision in case of conflict between state and regions, because they have each one's different powers, and some specific rare case of charges against the President of the Republic. Look at this aspect. How is composed the Constitutional Court? 1/3 of the 15 judges by the President of the Republic, 1/3 of the Parliament, 1/3 of the ordinary administrative Supreme Courts. So you see that the courts, the judges have an important role even in the formation of the Constitutional Court. Very quickly, to end this presentation, how works the proceeding in front of the Constitutional Court. We may have the state or the region that act against the Constitutional Court, in front of the Constitutional Court, in case of conflict of competence, or the most common case, in which there is a private or a public institution acting in front of a different judge. And in this case, this is so-called incidental form of claim, in which the judge having to apply a certain rule, make a question to the Constitutional Court in order to have an evaluation of the constitutionality of this legal rule. And this is quite frequent. So we have a very active Constitutional Court. And in this case, we have an action, a judgment of admissibility of the judge, and then a decision of the court. Okay, if you want to have a look of this basis, you may perhaps have a look at these books, and in English you find the book of Antonello Miranda, colleague of comparative law, who is quite helpful for foreign students and colleagues. I thank you for your attention. I'm ready to answer to your questions or observation. Please don't hesitate if you like to know everything, some aspect I didn't explain enough.
Thank you very much, Professor, for your lesson. And now our students have any questions in chat.
Okay.
Ага.
Let me see.
Can you see?
Oh, let me see. The chat. Let me see if I'm in condition to open the. Let's see. Sorry for. Why don't you? Okay, chat. Yes. Hello, Mr. Pernazza. In the graphic you showed earlier, the legal hierarchy of normative legal acts was indicated, in which the constitution and constitutional laws go first, and only the European directives. But lately, most experts have noted the tendency to increasing European integration, in which the European Union is strengthening its supranational status. Its directives are gaining more and more priority over national legislation. What is your opinion on this? Correct. Good question. Of course, as I said, there is a hierarchy principle following which we have a position of supremacy of the Italian Constitution on the ordinary national laws, both of national or regional levels. And if we compare the European regulations or even European directives and ordinary law, this was there were famous cases in front of the European Court of Justice, by the way, in which it was involved Italy, for instance, the famous Enel Costa case. At the end, the decision was the European regulation, treaties, regulation, even directives are have a priority over national legislation. This is already an established jurisprudence. What would be much more difficult is to compare European treaties, principles, and constitutional rules. We still think that the national constitution is our, let's say, highest source of law, and even the treaties are applicable because they are, let's say, the Constitution makes reference to the international treaties subscribed by Italy. So it would be difficult to say that European treaties have a priority position on constitutional rules. But this is very difficult case. I don't remember cases on this, but certainly on ordinary law, even national government regulations, there is a priority of the European legal rules. This is correct. I confirm. Thank you. Good question.
I have one question. Sorry.
Yes.
Yes.
May I read it, or this is a different one?
On the slide, on the slide of your presentation, I saw references to religions parts in the article of the Italian Constitution. And what is the relationship between religious norms and internal state norms in Italy? What kinds of religious norms exist besides the Catholic Church in the Italian legal system? And how are they regulated? For example, Islamic law in the Italian legal system. Thank you.
Sorry, I really had some difficulties to understand you. May I ask to my colleague to synthesize the question?
What is the relationship between religious norms and
Yes.
internal state norms in Italy?
You mean international norms in general?
No, state norms, Italy, and religious norms in Italy.
Ah, religion.
Yes. What
Yes,
relations
religion.
between
Okay,
these norms?
this is important. Okay. We don't have, of course, we have reference to the freedom of religion in Italy. But we don't, of course, Italy is a Catholic, is a country in which, in theory, the majority or large part of the population is a Christian or a Catholic. But the approach is of a like country. So we don't have any reference to the church as a source of law, not anymore. This was in particular very clear at the beginning, in which at the end of the 19th century, there was a quite strong conflict between the monarchy and the church, the Italian state and the church. In the 20s, we had a sort of international treaty between Italy and the Vatican, in which there were regulated the respective roles, the rights of the religious institution and so on. But we must not say that, of course, religious principles or Catholic rules have a legal force, like for instance in Islamic countries, in Islamic system. So the Catholic rules are not part of the constitution. Of course, on the contrary, the freedom of religion is protected, not only the Catholic religion, the Christian religion, to all the religions. Everywhere, more or less, with most of the more important religions, specific, let's say, agreement or treaties in order to permit all the functions, the ceremonies, and so on. But the general principle is a like country. Okay.
I have a question.
Yes.
What is the difficulty of the implementation of the decisions of international courts, for example, European Court of Human Rights?
Well, difficulties. Court of Justice, yes. Italy, was in some situation received sanctions or condemnation on some aspect, especially on economic aspects. And I would say that there is an evolution. It was something, I would say, new in the history of Italy as a nation, to have this sort of control from a foreign or international authority. And so this is something that had an initial reaction, even from the government, not so easy. But now I would say that the impositions of European, not only the courts, but also our organizations, we have on the tables in these moments very important decision for our economy. For instance, the Alitalia case, the problem on within which limits the government may finance public companies. This is very important within Europe because we have limitation or rules about state aids very restricted. And now I must say that there is a continuous, let's say, negotiations. When we reach the litigations situation, afterwards, normally, I would say the decisions are respected. Sometimes it can be more difficult. I quoted, for instance, the case of the length of the processes. This is not just a problem that may be solved with the decision of the government, because it's a very complicated aspect. And so we had large number of cases in which Italy was condemned because the proceeding was too long, and we had to approve a special law in order to reimburse the damages to the parties. But this was not the complete answer. So it is a proceeding. This is a proceeding. We had also exception, even sanction for very harsh treatment of people in prisons. In some cases, as you know, we have a problem with criminality and mafia and so on. So we had tough sanctions for in some cases, and we had cases in which Italy was condemned. And of course, this has contributed to change the system. It's not an immediate reaction, but I would say it's something that make evolve the system. Is more and more giving importance in our legal system.
Thank you.
Thank you. Very important question. Any other question?
Professor, we have a question in chat.
Yes, thank you. The last one. I noticed a strong similarity between Russian and Italian law, which suggested that the countries of the Romanesque legal family still retain common principles. But meanwhile, on the issues of international cooperation postponed by Italy's European commitments, how do you think it is worth building joint cooperation in such conditions? Yes, I know this is a great question. I'm very proud to take part to this program, because I think that beyond political let's say controls or difficulties, to keep a cooperation, at least in an intellectual and cultural perspective, is the best way to cooperate, to evolve. Of course, you can imagine how could be difficult to form an European Union. I'm of course, in favor of this evolution, because the single European countries, even the biggest, Germany or France or even Italy, alone have no worldwide relevance, I think. But on the contrary, this evolution that has taken already more than 70 years is something that is still on the way. And of course, we have this normal different position, still even in international relationship, different views with France, with Germany, before with England. And so this is a very big question. I think we should, I think in general, not only for Italy, we should keep this different form or different tables of cooperations. For instance, we have the European Convention on Human Rights. That is something that is common with Russia and with all the other countries of many other countries of Europe. That is a common table. Of course, even in the best families, there are different positions, different histories, different needs, and within Europe as well, within European Union, we have different evaluations. But I think, with Russia and Italy, we should find and give more and more importance to other different form of cooperation. I have difficulties to imagine a union of all Europe, all the continents, including Russia and Turkey, with the other countries of European Union. It seems very far from the actual perspective. But this not means that we have to give up, to establish and contribute to different tables of cooperation, because what is the worst for the international relation, at least is what I think, is to interrupt and to make walls, because making walls, the chance to find a peaceful and let me say even reasonable solution is more and more difficult. So to keep cooperation tables or cooperation occasion of meetings, even also only for academic proposal, diciamo, scopes, it is, on my opinion, very important. Okay, I have an answer. Thank you very much for your answer. I hope we can find the ways to allow existing. Okay, I agree. Thank you. We are absolutely on the same position, at least on this hope. But my hope is also to have the chance to meet you or other ASO colleagues in person, or maybe in Italy or in Astrakhan. I had already the great pleasure to come. I think it's time for ASO professor to visit my University of Molise, and I will be very proud to guest you in a future occasion. Okay, for me it's all. If you have any other question.
Ребят, есть еще вопросы к профессору?
Нет.
Okay. Students not have questions. Thank you very much for lecture. It's very useful, very interesting. Thank you very much.
Thank you. Thank you. Okay. Say you my greetings to the colleagues and to Ms. Popova, with which I had a good exchange of emails, and so we keep in
Yes, I
contact.
am.
Ah, you are okay. So,
Yes.
Ms. Popova, thank you for. So I still wait for your proposal of a lecture for my students. So if we can, it will be a nice cooperation. But I know that we are only few days already. But if we can do that this year, we will do it in any case in the future. Okay. Thank you,
Thank
everybody.
you very much.
Bye bye. Ciao. Ciao.
Buona giornata.
Ecco, dobre utro.